The topic I'd like to address is arbitrator challenges, which is sort of a hot topic in arbitration. The LCA just came out with the second batch of digests, which is really, I think it's 32 decisions covering some 6 years, which in itself is an impressive volume, but at the same time shows that actually there are not that many cases. But you might have a view on that, given your insight in the LCA rules. I thought you might also have some particular insight because you've recently been appointed on the DIS Council or court that will deal with challenges, so you must have an interest in this matter. And as I said, you have written about the topic in your book. Can you share with us your thoughts on the value of reasoned challenge decisions when it comes to the parties? So the parties that are involved in the arbitration, in some institutions you do, and in some institutions you do not get reasoned challenge decisions. What is your perspective on that?
So I think it's actually like most decisions, not only challenges, but all of the decisions. Giving reasons just enhances the acceptability of the decision. If you know why the decision makers have gone one way or the other, it makes it easier, obviously, to understand and accept and that decision. I don't think there's anything special here, and I remember actually an article I think Lord Bingham wrote in the 1980s, which he called Reasons and Reasons for Reasons, and where he developed actually exactly that, how important it is to provide reason, and he compared court decisions and arbitral awards on this. But I think on challenging decisions, more importantly, it is for future decisions. It's not only for the parties in this specific case, but it is also for the parties to actually know how this will develop in other cases, and therefore not only for the parties, also for their counsel, the arbitrators and decision-making bodies, national courts, the LCIA court, etc., to be able to know how previous decisions have come out, and sort of in order to develop some hopefully consistent and stringent standard.
Indeed, and that touches on the second stream, if you will. What is the value also to the public that informs the parties and informs others? But before we leave the parties themselves, this would come at a price, of course, and that's what we see under the LCA system, that you pay for the challenges, or rather the losing party pays for the challenges. So it is sometimes said that if you just make it a lighter procedure, then it's less of a burden on the parties, and that might outweigh the advantage of having a reasoned decision. What is your view on that?
I don't think so. I think this is a small portion really of the costs of an overall proceeding, be it administrative costs of the institution, be it the arbitration costs of counsel, more importantly. So I don't think that would necessarily weigh in. And the parties have the choice. I mean, if they don't like that aspect of the LCA rules, they can go elsewhere. Yeah. And so they have a choice amongst the different institutions. And I don't have the impression, I would be surprised that parties sort of opt out of the LCA rules for that reason, that it becomes costly to have a challenge decision.
Yeah. If we then move to the benefit of having guidance on what is and what is not acceptable behavior for parties, but also for future parties. What I find an interesting relationship is the relationship between the institutional role and the role of the courts, because of course ultimately the courts are there to protect certain fundamental norms, and we have some decisions both in the UK and elsewhere dealing with, well, what is the role of an institutional's court body compared to the role of the courts, and that might also be something that has influenced the decision of DIS to create a more permanent structure that would deal with decisions. There are, I know of statutory developments in some countries where you see that the heavier the institutional procedure, the more the courts will step back. What have you seen in that area that interests you and where you think that development has been made?
Well, I think the first development obviously is that national court decision, traditionally challenge decisions by courts, are public and in an anonymized format, obviously, but they're generally made public. And the institutional decisions are not necessarily.
Yeah.
I mean, the LCIA has
Yeah.
changed that. And some other institutions also publish summaries of challenge decisions, not necessarily the decisions themselves. So there is a bit of a distinction here between whether you go to a national court or the institution. Interestingly enough, and you know this case very well, is the recent case in the UK. It's a 2017 case, which is P versus Q and others. Nice title, obviously, to protect the anonymous nature of the arbitrators. Where here, just in a nutshell, for those who might not be familiar with the case, the claimant had initially challenged in the first step the entire arbitral tribunal before the LCIA, correct me if I'm wrong, and the LCIA Council had only accepted a challenge regarding the presiding arbitrator, but not for the other two. And then later on, the claimant also challenged again the entire tribunal under Section 24 of the English Arbitration Act on similar grounds. And the court here actually referred back to the decision of the LCIA and said, agreed with the LCIA and dismissed the application and did say that the court should really only depart from the LCIA decision in important cases. And they said, well, the parties have actually chosen the forum, which is the LCIA being the first and foremost decision maker on challenges, and so has sort of given a certain hierarchy between the institution and the court, which obviously supervises if there are issues, but generally gives a certain deference to this decision of the institution. I think that is quite important.
Yeah, and that's what you, I imagine, also anticipate will happen in Germany. Presumably, the more solid the internal procedure, the more comfortable you are that there will be as little interference afterwards.
I will be able to tell you that in our next interview.
In 2.5 years. That sounds like a good deal.
Once we haven't actually started that council yet, so.
Well, before we leave this topic, and I apologize if I asked a sort of leading question when I referred to the relative paucity of LCIA decisions over the last few years, because when you go to conferences and public speaking engagements, people always talk about the staggering increase in challenges and the enormous number of cases affected by challenges or potential challenges. What's your view on that? Is that real, or is that a perception? Is it true across the board?
Well, obviously, I sort of checked the numbers to be able to answer that question, and we all have that sense, right, that there is an important number of challenges of arbitrators, particularly in the investor-state arena. And so I looked at the numbers, and I've particularly looked at the LCIA database, and I've looked at this before. And I'm surprised each time how small the challenges number actually are. Last year, 2017, 3 challenges overall during the year. And then if you go back the last 7 years, it really sort of averages about 4 or 5 challenges per year. Compare that to the caseload that you have, which obviously is different in different years, but is something between 250, 350.
Yeah.
I think roughly.
Yeah.
So it is only a really small proportion. And of those small number of challenges, and I have the figures here, actually only very few are upheld. So in the last 7 years, overall, across the 7 years, were 32 challenges and only 6 upheld, 1 partially upheld, which indeed is a very small number of cases. Now, I've also looked at investor-state arbitration because you might ask, that's different, and it is to a certain extent different, but not as different as one might think. And I looked here at the ICSID statistics, and again, the number is fairly small. It is averaging in the past years about 10, 11 cases per year. That is not very much. It's actually again, compared to their caseload, a fairly small number. And maybe even more striking is the fact that of the 69 challenges that they had in the past 6 years, 48 were rejected and only 3 were upheld. This is less than 5%, if my math are correct. So I think the sort of common sense that there are these massive amounts of challenges of arbitrator cases is, to a certain extent, slightly twisted by the perception we have of certain cases that we all know of where there have been repeated and multiple challenges. But the numbers are actually very small. What the statistics do, however, I think confirm is that a lot of those challenges are actually unfounded and are dismissed.
Yeah. I like the fact you referred to facts. Several publications that the LCA have come out with recently are entitled Facts and Figures, and I personally genuinely believe that people should look at facts first before they start interpreting and giving opinions, and this very much is an area where it is wise first to check the numbers before you draw too many conclusions. Now, if you have a publication that gives you insight in the actual decisions, in addition to information about stats and procedures, it is interesting to see whether you can discern a pattern in the norms that are developing. That would also be reflected to some extent in disclosures and people simply no longer taking certain cases. So I'm not suggesting that the digest is the exclusive source of information, but the whole area of arbitrator acceptances, of arbitrators accepting cases, has developed quite a bit, even in the 2.5 years that passed since we last sat here. How is that affecting you in your practice? For instance, do you still need to discuss with clients and co-arbitrators the difficulties in having arbitrators from the same chambers or arbitrators and counsel from the same chambers, or has that now settled?
I think that very much depends on the cases, and I think I've seen a number of cases recently, LCIA, but also other London-based cases where it wasn't a problem. There was an arbitrator from one chamber and representing by a barrister from the same set of chambers, but it was very much English parties and they're familiar with the system. I think it's very different if you have parties, international arbitration proceedings, and you have parties from outside the English system. They're just not familiar with the set of chambers, and they're not familiar with the fact that you can have a counsel and a barrister. And really the worst case scenario is if the barrister QC sort of turns up at the hearing or shortly before the hearing and no one knew that she was there before, and then all of a sudden you wonder who that is, and then you even find out that they're from the same chambers. And that for international parties becomes very troublesome. And this is where I think really here communication and information is key, and the fact that you disclose it solves that problem. And I've seen that, as I said, in a number of cases. It was disclosed, it was accepted by the parties, and then you don't have a problem going forward. And in that, I particularly welcome one of my favorites in the LCA rules, which is Article 18.3, which actually does exactly that, that any change or any addition in the parties' legal representative teams has to be promptly notified to the arbitral tribunal. And I've used this again and again and again in LCA proceedings recently. I think it's a very important addition to your rules. Yeah,
and even though Article 18 doesn't give guidance on the merits, it has indeed coincided development of Article 18 with the development of the substantive rules. And at the LCA, the practice now is that there has to be explicit agreement from the parties that they do not object to parties, counsel and arbitrators from the same chambers, which is a different situation than a few years ago.